What's that? Phone?
Most of us. No, my lord, sorry, my vote was a bit low. Can I just get the directions again, kindly?
Ruling on the 19th of March, on the 8th of March, I'm sorry, 8th of June. 8th of June.
The 17th of March. It's 8th of June.
Ruling on 8th of June. Ruling on 8th of June. Then I'll give directions, further directions as to the prosecution of the application dated 19th of March. After the ruling. That is
17th of, you said 17th of June. 8th of June.
8th June.
8th of June.
From Monday to Thursday.
Thank you very much and good day to yourself and to council.
Now calling petition number E11 of 25, most of Kisumu, Dallas, National Safety, Dallas.
Good morning, Lord.
Good morning.
Dr. Wilson, here together with Mr. Willis Otieno and David Chesi.
here together with Mr. Oma, Bonu, Ms. Mwangi, and Mr. Mbaya for the response. My colleagues are telling the other report, but they join us, but the three of us are, four of us are.
Who is present?
Mostari is out. Mr. Oma is here.
Just want to appreciate.
I swear by the Almighty God,
I swear by the might of God,
before this honorable court,
for this honorable court,
the evidence I shall give,
the evidence that I shall give,
touching the matter in question,
touching the matter in question,
shall be the truth,
the whole truth,
the whole truth,
the whole truth,
so help me God.
so help me God. I'm Josephat Mushiri, representing the National Biosafety Authority.
I will seek some clarification because the time you can ask questions on, so I'll leave you as you clarify now. Please, let's go to your panel. Open page number 6. That from your evidence running from paragraph 12 to paragraph 25 of your reply affidavit, there was no this can you paragraph number 12, my lord, all the way to paragraph 25.
Yes, I do confirm from those paragraphs you referenced, there is no direct involvement of the counties. Genetically modified organisms are the GMOs. And when you look at Schedule 4 of the Constitution, regulation of genetic modification technology, not the actual crops. With the approval process, when that GMO technology is put in a variety or a crop, that becomes the mandate of ethics. Now, when it comes to the GMO, for example, if you are dealing with beating maize, so you have your conventional maize, and you want to introduce, for example, try one egg crop. That crop is what we call a variety. So the farmers will directly do the variety. The of NBA stops at the event approval.
At the event approval?
Yes.
So what does NBA approve?
NBA approves the GM technology. What happens when the GM technology that has obtained biosafety approval from the NBA grants biosafety approval of the event? The developer will proceed to the next level of agency. It's called the environmental impact assessment of that GMO event. And their process is guided by the MCA Act and also the regulations.
The name has approved, where is this?
So after NEM approves, the developer will move from there, will go to KEFIS, Kenya Plant Health Inspectory Service. KEFIS will...
And you made reference to the case of LSK versus the Attorney General, that's found at page 20, which is made reference to page 33. Yeah, and just confirm who is the second respondent.
The second respondent is the National Biosecurity Authority.
National Biosecurity Authority. So briefly to the specific area I want you to you are taken read paragraph 331. Of the judgment, which is captured at page 86. This read that paragraph 331 in full, you are not allowed to read it.
So paragraph 331,
Yes.
in conclusion, it is the finding of this court that the petitioner has not challenged the constitutionality of the laws governing GMOs, both international and domestic. The regulatory barriers that govern importation and cultivation of GMOs remain in force, and the same are presumed to be constitutional until the contrary is proved.
Until the contrary. Let's proceed to paragraph 333.
Okay. Paragraph 332. The evidence before me shows that the country has put in place robust frameworks with inbuilt structures which must be met before the various agencies can consider and determine applications for approval of the transfer, handling, and use of genetically modified organisms.
Okay. So as the court is making reference to the issue you are asking of the constitutionality and the legal framework. Okay? So what does the court make out of those two paragraphs?
My interpretation, the court is saying the constitutionality of the Biosafety Act and the relevant regulations has not been challenged. And in the absence of that challenge, it is presumed to be constitutional. 332. The evidence before me shows that the country has put in place robust frameworks with inbuilt structures. Okay. Oh, I thought it was a typo. Okay, let me read it again. The evidence before me shows that the country has put in place robust frameworks with inbuilt structures which must be met before the various agencies can consider and determine applications for approval of the transfer, handling, and use of genetically modified organisms.
Whether the issues, the legal framework and the constitutionality of the act has been questioned. Can I explain?
My interpretation of this paragraph 331 is that the constitutionality of the laws that govern GMOs has not been challenged, and in the absence of that challenge, it is presumed that the laws are constitutional. Now, if you look at paragraph 332, the court concluded that the country has established a robust regulatory framework to determine the safety of GMOs.
I have one more brother about it. Let's go to 339.
Page number?
Paragraph 339.
Okay.
Thank you.
I can proceed.
Yes, proceed.
Paragraph 339. Let me add. Okay. Paragraph 339. Let me add by stating that as a country, we need to trust the institutions that we have in place and call them to order in the event they breach the law. The Biosafety Act stipulates that the National Biosafety Authority should work in close collaborations with the Department of Public Health, which safeguards the health of consumers through food safety and quality control, surveillance, prevention and control of foodborne diseases.
So my emphasis on the first line, just read it up to place.
Let me add by stating that as a country, we need to trust the institutions that we have in place.
Yes, that's enough. So the court calls upon all of us to do what?
To trust the institutions that have been established by government.
Let's proceed. I will ask you another area that you also question, which is related to where I replied. You are asked that by excluding the county government from your approval process, you had violated the fourth section. Where are the objections? What is your response?
As I said, the National Biosafety Authority regulates GMO events. And when you look at the Schedule 4 of the Constitution, the regulation of biotechnology and the GMOs in general are not listed in Schedule 4 of the Constitution. Now, if you look at Article 186 of the same Constitution, it says if a function is not listed to be a function of the countries, it automatically becomes a function of the national government.
Thank you. That's fair enough. For clarity purposes, you've mentioned another institution that you work together. That is NEMA. Could you explain whether since that promoter is a regulator?
The NBA or the NEMA?
NEMA. Institution that you know will be a regulator and also not a regulator.
I know of, for example, the National Construction Authority.
That's fair enough.
Yes.
I want you to clarify on the right of farmers. You were asked a question whether a farmer who wants to cultivate his maize will require to have a license from NBA.
A farmer is not required to get any permit or license from the National Biosafety Authority.
You are asked by my colleague Betty on the environmental rights of becomes the assistant chair, but now in the security and control of the environment, where that's where that point sits. But the enforcement mechanisms and the regulations is by the National Environment Management Authority as a regulator. The prosecutor is the NEMA officer. The prosecutor is the NEMA officer. The judge is drawn by the NEMA officer. Licensing actually is the what is devolved. What is devolved? Especially the licensing. County, I think because of the levies, they now also give the licenses. But the control, arrest, and judging the NEMA officer. Those are my colleagues are over different opinions, but I think I am right. That's the way you get it. Yes. So let's go to the precautionary principle that is highlighted at Section 2 of EMCA Act. You are asked whether NBA has put in place mechanisms to protect the environment and farmers from any violation.
Yes. Have a regulation that provides.
Please.
Yes. Yeah.
It's enumerated at section. Okay. And whether it's also in
The principle for the precautionary principle, which requires you take precaution for technology which you don't know its final outcome. What we have done as an authority, because we regulate a GM technology, we have published a regulation. Oh yes, it's part of the policy. As a start, we have a regulation that is customized to take into account that precautionary principle. What is required before a GMO station? What that regulation requires before a GMO goes to the public, it is subjected to trials at that GMO at that level, at that research phase. So we give trials, and that permit is given for 5 years. Laboratory and the greenhouse experimentation of the GMOs, 5 years. Now, if the data at that phase indicates there is no adverse effects, we proceed the trials to what we call the confined field trials, which are also given a permit for 5 years as we observe the GMOs.
the people involved in those trials.
Yes.
This just answer this question. Right?
Yes.
For clarity, so I'm sure you answer what you want to clarity on is whether in your operation, in the precautionary principle, there is an environmental assessment being conducted by other agencies you work with. And I draw your attention to, let's go to paragraph 16 of the plan. Let's begin with paragraph. Let's paragraph 11. Then look at E. Paragraph 11, E. Read the regulations that is provided among the.
Contained use regulations, 2011.
Okay, so we have the contained use regulations 2011.
Yes.
Then now let's move to paragraph 16.
The praise of relevant stakeholders in the approval process cannot be gainsaid. According to Section 27 of the Biosafety Act, where the application for approval has been screened assessment on information submitted by the applicant.
Thank you. So then, let's go to paragraph 23.
Paragraph 23.
Yes.
Pursuant to section 29(2) of the Act, NBA is required to write 29(2) of the Act. NBA is required to liaise with the NEMA, which is required to submit to the NBA any conditions that the regulatory agency considers appropriate to be attached to the approval. Pursuant to section 29(2) of the Act, NBA is required to liaise with the NEMA, which is required to submit to the national to be attached to the approval. Correct.
Yes, and close on that. Go to paragraph
26. Further to the decision to paragraph 25 above, any GM crop undergoes mandatory environmental impact assessment pursuant to provisions of the MCA Act and distinctness, uniformity. Paragraph 26. Undergoes mandatory environmental impact assessment pursuant to provisions into bracket NPTs and stability test into bracket DUS pursuant to provisions of the Seeds and Plant Varieties Act, Cap 326, which is conducted by the third respondent.
So, you are demonstrating for clarity that there is a compulsory
Yes. What happens before any crop variety is released to the farmers? What the third respondent, which is capital, they plant the variety that is being evaluated vis-a-vis the existing varieties that are in the farmers in the various agroecologies, various counties. Basically to see
various fields.
Various fields. They are trial sites. Basically to check the agronomic performance and the expression of the trait that you are testing. Basically to compare the variety you want to release vis-a-vis what the farmers have. Whether the one you want to release has any superior advantage or what the farmers have. Yes, they are done. Yes, Seeds and Plant Varieties Act, yes.
Or release variety.
Correct.
And it is what is carried by the relevant authority that's there. Now, I want you to explain something that you have taken a bit of a debate here on pollination and cross-pollination. The question was put to you whether cross-pollination
yes, I said for certain crops, they are cross-pollinated. For maize, it is among the crops that are cross-pollinated. Now, once cross-pollination happens, it is actually irreversible. I want to confirm that.
And the issue of condensation arising from cross-pollination?
Let me see, the cross-pollination is basically a very natural process when you plant varieties in the field. Because as we speak now, we have different varieties of maize. We have traditional maize, we have open pollinated maize, we have hybrid maize. So pollination is a natural process, but if anyone would like to pursue a compensation for whatever reason, that person can go to court and seek compensation, but it's generally
there is cross-pollination from the BT maize to conventional maize.
you have the open pollinated varieties, and then you have the hybrids. Now, when you have the BT maize, pollination will still happen between the conventional and the BT maize. And it will happen in both ways. It has been happening. What should happen to the conventional maize that has received the BT pollen, it will have
I'm just serious. I've never seen someone.
So in BT maize to conventional, it will add them.
what would happen, it will slightly dilute insect resistance a bit in the next generation of the crop if you have to replant that seed.
The BT. I'm very curious. So if there is a BT farm and a conventional farm, because pollination happens from
Your maize is likely to have some trait, insect resistant trait that was not originally in your crop. Most
that will be processed from that pollination.
yeah,
Upon replanting, we'll have that insect resistance.
a bit of it,
A bit of it.
yes.
And I want you to look at the provisions at paragraph 11. H is
11H.
H, regulations. That's the data. Regulations of the
11H.
Okay. And so, the court asked the purpose of labeling and you clarified. And so the concern is whether the farmer,
Either the package,
the GM to the consumer.
to the consumer, yes.
Okay.
Consumer, yes.
Okay.
Any person, any importer, for example, if someone intends to import a genetically modified product for purposes of sale, that person is required to label. Manufacturers,
So importer,
manufacturers, and any other operator who is dealing with GM products, whose intention is to take it to the market.
and what is the allowable level of GM products?
Yes, it provides the manner both for packaged and prepackaged goods. Yes, it's very specific. Yes, how it should read. Contains approved GMO. It's prescribed in the regulation.
It contains approved GMO.
Yes.
And GM that does not require labeling?
Yes, the labeling requirement is for any GM product whose GM.
So for a farmer who farm has been cross-pollinated with GM and
is 1% at the group, does not require any labeling based on the current law.
You are asked whether you still stand with the contents of that document.
Yes, I do.
And what will be the clarity of why you still hold it? Well, it was and so what makes you still stand with the contents of that paragraph?
I will start structures to assess the safety of the GMOs. Now, before the authority approves any GMO product, someone wants to challenge. Now, the decision of the regulator, he or she needs to go and decides to go to court, needs to come with the evidence that that structure has not been complied with. Because we don't approve GMOs in general, we assess specific GMOs as they come to the authority. A biosafety clearinghouse is an online platform established to freely share biosafety information and decisions in regards to GMOs from the specific countries that have signed the Cartagena Protocol on biosafety.
Is anchored in the Cartagena Protocol?
Correct.
Is among the legal framework that you have highlighted which govern GMOs. Just read paragraph 11B. And that's where the BCH is anchored.
Correct.
And how do you, what are the meetings that, because you are asked whether you attend meetings and whether scientists or laymen from the country advance Kenya's interest. What is the name of the meeting that takes place under the biosafety?
Those meetings are called COP-MOP meetings. COP-MOP.
And a phone?
So COP,
Yes.
COP is conference of parties. MOP is meeting of parties. MOP. So those meetings are held every 2 years.
They are held. Have
173.
173. How many members have signed into the biosafety clearinghouse?
It is still the biosafety clearinghouse is not it's not a signatory. It's just a platform. So as long as biosafety clearinghouse.
So the members are the ones that members are automatically part of the
BCH, correct.
How many countries have approved GM maize for cultivation?
About 30 countries.
About 30 countries.
Correct.
So for clarity, why is what is appearing the number below? The question that was posed to you.
So why, Patrick, the Cartagena Protocol was enacted in 2000. It was adopted for use in 2000, but it became effective in 2003. And one of the requirements the protocol requires, it requires state parties to domesticate that protocol in their national policies and the national laws, and also to establish biosafety agencies to regulate GMOs. Now, if you look at some of the least developed countries, developing countries, and countries in transition, they have largely struggled to domesticate this protocol, because it requires to domesticate this protocol, because it requires resources, government resources. Based on that capacity challenges, you find the adoption of the GM technology is moving but progressively slow.
So our Biosafety Act is domesticated as a form of the...
And even the establishment of the national biotechnology by itself is part of the domestication of that protocol. Yes.
And that question the court has asked for clarity to the court. Before we enacted our Biosafety Act, can you explain briefly in 1 minute what led to the domestication?
So after the government signed the Cartagena Protocol, the first thing that happened is to develop the National Biotechnology Development Policy that was approved in 2006 by Cabinet. The government developed or published the National Biotechnology Development Policy in 2006. So after that, we had the Biosafety Bill that was approved by Parliament in 2008. In February 2009. It is the Biosafety Act that established the National Biosafety, after which the authority then embarked on the publication of relevant biosafety regulations.
The various regulations which have been established pursuant to 11 D. Thank you for sharing this on consensus, whether there is need for scientists to have a consensus on this issue of GMO and the on water. The spring may last
Okay. I'm not aware about the consensus that would be required for GMOs. In the general discussions and debates on any thematic area, there's rarely consensus on anything. As a regulator, therefore, we are not looking at consensus in the debate. Our assessment of GMOs is a very scientific process that is guided by international protocols. and also the international, and also the domestic laws. I've not had any consensus, even the lawyers. If you read, because our legal teams, you find different assessment of GMOs.
And publication on consensus on water?
I'm not aware about the consensus on water. What I know for a safety assessment, I know for water it must be assessed by KEBS to ascertain that water is going to be consumed by the public.
So there is also an
Okay, Mr. Mshiri, I'll be brief on public participation, but you are asked whether a product, if it poses threat, it can be recalled post-approval. Is that correct? You are told that it can be recalled if it poses a risk. Is that correct?
So one of the inbuilt structures of the Biosafety Act, it provides for a cancellation of permit if new information becomes available that was not there. So that's why you have the label, what you are calling the traceability through the label.
So,
okay.
So, could you find on what you say?
What I've said, the architecture of the Biosafety Act provides that the Biosafety Act or the National Biosafety Authority can cancel a permit that it has issued if new information becomes available on the safety of that product.
So how long do you take to monitor a product post-approval?
We monitor approvals different durations. For research,
That's right.
okay.
Proceed.
We give different durations of approvals. For research, the approvals are limited to 5 years, but they can be renewed based on request. The approvals for commercial release, that's for cultivation, the approvals are tied to 10 years maximum, which is also reviewable based upon request.
So do you have an inspector who does this monitoring?
Yes, the authority has biosafety inspectors who are mandated to monitor approved GMOs.
So you confirm that you monitor each event that has been approved by National Biosafety Authority?
Yes, I confirm.
You confirm you've relied on the decision in Law Society of Kenya versus National Biosafety Authority in the environment and land. Confirm that the issue of precautionary principle was tested in that court.
Yes, I confirm.
Yes. That shows that you complied with all the precautionary principles. Is that correct?
Correct.
But for your noting, I would want you to confirm that indeed the court assessed and affirmed that all the precautionary requirements under the law are compliant. 311 requirements for precautionary principles under the Act and other agencies and how the National Biosafety Authority complied with that. Participation. There were allegations that you have not adduced before this court anything to show that you conduct public participation. Is that correct? Confirm that the case revolves around the process of approval of GMO. Is that correct?
Correct.
Now, confirm. Now, confirm that the authority provided evidence to show that it conducted public participation. That paragraph 249 has two subsets of paragraphs. The first part, then there's a point that starts with that.
Paragraph 249, as was held in the case of Samu, Mumin, Muhammad, and 9 others, that being the case, it is the finding of the court that there was. That being the case, and its varietal derivatives in Kenya on 18th June 2015 by the...
There was the issue of awareness. Now, confirm that under Section 7.2 of the Biosafety Act, you have a duty to promote awareness and public education with which you create awareness to the public on biosafety. Is that correct?
Correct.
Could you clarify? To create awareness to the public on biosafety.
So we have, as an authority, basically to implement that function given by the Biosafety Act, the annual Biosafety Conference. And the last one was, the last conference was the 13th Biosafety Conference.
Do you put publications in Maize
programs on various mass media channels, including the TVs, for example, the Citizen, radio? Yes.
Now, there was an issue of scale down activities in relation to awareness measures for VTMA. Could you confirm that there exists a conservatory order stopping the authority in relation to PT Maize?
Yes, by this court.
By which court?
This court.
High Court.
The High Court, yes.
Not for clarity. There's Paul Mangi and another was Attorney General. There's a conservatory order by Justice Pandey. It prohibits the authority to stop approval of VTMA cultivation and exportation. It's in relation to the cabinet memo that was issued in 2023, and it's questioning how that cabinet memo was provided. It's related, and just for judicial notice for your consumption, it will lead me to the next question.
Please give the case number.
Paul Mwangi and 2 others, that's the Attorney General, and 3 others, 2022. And we have 5. It's a petition.
It's petition E475 of
E475
2022.
2022.
Yes.
Filed by
Miliman High Court.
My Lord, at this point, I wish to seek the court's clarification. My understanding of the exam that parties are limited to what transpires across. Yes, and as it is now, we are now moving to very dangerous territory, including introducing matter that seems to be alive elsewhere, which we never raised across examination. But I do appreciate my colleague. What if it exists?
Actually, I think what is the witness was asking the witness as to why there has been no attack. You brought it in
Yes, I did.
on the issue of awareness. Yes. And you are saying that since then you've done nothing.
Yes.
So he's asking why haven't you done?
Actually, my lord, I was going to just request, I was not even objecting to that line.
Yeah.
That since it's a live matter, I have noted that the court has recorded it, so that we all be on the same page. Council can undertake to supply all of us to proceedings or things that you find in that matter and the orders which exist, so that we all get to benefit.
I was actually asking that because I wasn't aware that there was another matter. That is why specifically I asked whether
It's a fact. I go to my lord's.
I'll be able to supply counsel. So this is the last question. Would you attribute that conservatory order to a scale down on awareness initiative with religious beating?
Yes, it has an impact. Because
It has an impact.
yeah,
It is the reason why you scale down awareness in relation to beating. Is that correct?
correct.
That's all.
Your Lordship, that will be the end of the explanation of the exam.
Thank you very much, Your Lordship.
My Lord, we can proceed to the last witness. Very brief. Yes, very brief, ma'am. Indeed brief.
most countries
Yes.
go on and on.
Somebody have the last English takes forever. But
So that will be your last witness.
yes, my Lord.
We'll be closing down.
Yes, we will.
Please, let's have a short end break. We will resume for about 15 minutes.
That's okay.
say you want to affirm?
Okay.
That you can. I affirm by the Almighty God
I affirm by the mighty God
and before this court
and before this court
the evidence I shall give
the evidence I shall give
touching the matter in question
touching the matter in question
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
so help me God.
so help me God.
My Lord, in the matter I'm on board, and the witness before you is a representative of the third respondent, Mr. Maize. My Lord, we did file a replying affidavit.
Just a minute. Let me know your name.
My Lord, my name is Simon Musheru Maina.
Simon.
Musheru Maina.
Where do you reside?
I reside in Ngong, Kajiado County.
And what do you do for a living?
I work, my Lord, I work for the Kenya Plant Health Inspectorate Service, KEFIS, as a director in charge for seed certification and plant variety protection.
In charge of seed certification.
Plant variety protection.
Yes, Mr. Mwabonda.
Yes, Mr. Maina, did you file any replying affidavit pursuant to the case before the court?
Yes, my Lord, I filed an affidavit on 24th of July 2025.
It's, when is it from?
24th of July 2025, my Lord. My Lord, the replying affidavit has two annexes, SM1 and SM2. And the witness will be relying on those annexes also. And we wish that be used as part of evidence. Mr. Maina, I want you to tell the court how many years have you worked with KEFIS?
My Lord, I have worked with KEFIS for the last 24 years.
In the same
24 years.
Is it in the same position?
No, my Lord. The current position I've worked for 2 years. Over the other years, I've held different positions.
So, Mr. Maina, in the 24 years you've worked with KEFIS, what is the mandate of KEFIS?
My Lord, the main mandate of KEFIS is to regulate on matters relating to seed quality, plant variety protection, and plant variety testing.
KEFIS regulates?
Matters on seed quality, plant variety protection, and plant variety testing. My Lord, as part of that mandate, we facilitate the release of new varieties of plants, including maize, for commercialization by farmers. We also regulate import and export of plant materials. And also, my lord, we offer advisory services to farmers on matters of plant health, seed quality, and other related issues.
Matters to do with?
Plant health, seed quality, and other related issues.
Does your mandate also involve, does your mandate involve GM varieties?
My lord, as I mentioned, we regulate matters to do with testing of new varieties for commercialization, and these varieties include GMO varieties.
What is your relationship or collaborative aspects with between yourselves, KEFIS, and the National Biosafety Authority, particularly in relation to seed and plant varieties?
My lord, KEFIS is one of the institutions that have been recognized as having an interest on matters biosafety, particularly on matters to do with seeds and plant varieties, any matters on plant materials. And therefore, we come in, for example, when it comes to import and export of plant materials that are genetically modified, then we'll come in because we regulate import and export. When it comes to testing of varieties of crops that are genetically modified, we come in because of our role in testing varieties. And when it comes to seed quality assurance, varieties will also come in. But there are other institutions that support NBA because of their mandate, like the Directorate of Veterinary, the Pest Products Control Board, depending on their mandate.
So the relationship with the regulatory body?
Yes, my lord, is not unique because their mandate on biosafety, when they release what we call events, these events are already put in plant varieties, and of that event is adding value to the farming community. So basically what we do at KEFIS, we test the variety. NBA will test the event in terms of biosafety, but as
Are there any other regulatory bodies that work with KEFIS in the same way?
My lord, plant variety testing is unique to KEFIS, which is the mandated competent institution to undertake variety testing. The other bodies handle mandates that are related to, handle issues that are related to their mandates.
Mr. Maina, in brief, of GM testing, GM material testing, and release for commercialization, particularly in relation to the GM varieties?
My lord, testing of GM varieties follows almost the same route as conventional varieties. The only issue is that being genetically modified varieties, for us to be able to test those varieties, we must get prior approval for National Biosafety Authority that they have allowed that material to be grown in the environment. So basically, an applicant who is seeking to have a new variety tested will make an application to KEFIS for testing and attach an approval letter from the National Biosafety Authority. Once KEFIS is satisfied that the application is complete, we initiate the process of testing.
Does the approval from NEMA come before or after?
The approval from NEMA comes before.
Before, after what?
Yes, before the application is sent.
Because he has talked about the event.
Yes.
He has talked about now
Correct.
the approval by the NBA, then it goes to KEFIS. So before exactly what?
Yes, upon approval of the event by
NBA.
by NBA, do they seek any kind of approval from NEMA, or is it after the applicant comes to KEFIS?
My Lord, there are different scenarios. The first and perfect scenario is where NBA works with NEMA to have what we call a full environmental release. And then the material now comes to case for testing when it has been released to the environment. However, we have had scenarios like the
NBA works with NEMA to have a full what?
environmental release.
Environmental release.
Yes.
Yes.
But we have scenarios whereby the testing by KEFIS is allowed before the full environmental release. So in that case, the testing is done under what we call restricted conditions, under confined conditions. So the ideal is for the full environmental release, which has involved NEMA, to be done. But there are scenarios where testing for NPT is conducted before the full release by NBA with the involvement of NEMA. In that case, the testing will be done under confinement.
So what kind of tests does KEFIS do?
The first test is the national performance trials. Basically, the national performance trials evaluate the variety for performance, and the general Sorry, my lord. My lord, the national performance trials. This involves, these are experiments that are conducted at different locations within the country. And the general principle is that the new variety should perform better than the varieties that are already in the market. This test involves
NBA gives the approval, NEMA gives approval, but the variety fails in this case.
Yes. Yes, my lord. This scenario happens, as we say, NEMA approved the event, but then the breeder will have that event in a variety.
So who approved the event?
NEMA approves the event, but now the breeder inserts the event in a variety which comes to KEFIS for testing.
Yes.
So we had a particular case whereby when we tested a variety, it failed to pass the DUS test, and therefore it was not recommended for release.
I want you to be quite clear. Is it NBA or is it NEMA that approves the event?
My Lord, the event is approved by NBA.
That's what I was asking. You were saying that there are scenarios where NEMA approves the event.
No, sorry, that is wrong. That is not correct. My Lord, I'm sorry for that. It is NB that does the approval. As I had said earlier, there are a number of institutions that play a role. So there is consultation with other institutions, but ultimately the approval of the event will be done by the NBA.
My Lord, with your kind permission, and I always do this with tremendous pain in my heart. I don't like to interrupt my colleagues when they're doing their exams. But I am now constrained to feel that the witness is going beyond the parameters of what is in the affidavit. And I really think that having filed the affidavit, this testimony should be restricted to the affidavit. So that is what we prepared for today. So maybe if my colleague can just limit himself to what is in the affidavit.
Yeah, my Lord, we are not introducing anything new. It's just expounding for the court's benefit, because all these processes have been explained in the affidavit. But
what is the new material being presented, Mr.
My Lord, the entire part of what is discussing, that section, what is there saying, is all outside what is in the affidavit. Because in the affidavit, the relevant component, which are two, is found in paragraph 8 and paragraph 9 of the affidavit. That's addressed in the first section of his exam in chief. But now he's moving to details. What I'm hearing for the first time is I'm trying to Google and keep a pressure on what I say in the database. I'm now doing another trial beyond what I prepared. So if only can limit it. I'm not saying I have no problem with the witness being ready for this. I have no problem with that. But just limit it to specific sections of the affidavit.
So as much as possible, limit?
yes, my Lord, what we are covering just covered from paragraph 7 to paragraph 10 of the claim of the witness, but I'll abide. So after these tests are done, what happens?
My Lord, when KEFIS undertakes the tests, data analysis is conducted because they are scientific.
You are just the witness. But that's scenarios where the NBA approves and KEFIS does not approve through the tests.
Yeah.
And then what happens?
There are scenarios where they would deny.
Yes,
They
then
would
what
fail.
happens?
They would
To those
fail.
varieties.
Yes.
Yes.
Yes. Then what? Varieties.
My Lord, the variety that does not pass the test stands rejected.
What follows next?
My Lord, once a variety has been tested, KEFIS technical team undertakes data analysis and develop and generates a report. And that report, my Lord, is presented to a committee, the National Performance Trials Committee.
What is the work of this committee?
My Lord,
The National Performance Trials Committee.
My Lord, the National Performance Trials Committee assesses the report that has been generated, and based on defined criteria, makes a recommendation for qualifying varieties to be
So from the national performance,
this committee considers the recommendation of the National Performance Trials Committee and also considers socio-economic factors. My Lord, once the release committee is satisfied, it now approves the new variety
including GM varieties.
My Lord, the county government are in membership in the National Variety Release Committee, centered in the National Variety Release Committee by the Council of Governors.
All right, because you first said that the county government are members.
Yes, they are members of governors.
Represented before which committee?
The National Variety Release Committee.
Composition of the National Variety Release Committee.
My Lord, the membership of the National Variety Release Committee consists of that is a representative of the Council of Governors, that's how it is stated. A representative of the Plant Breeders Association of Kenya, and KEFI.
Apart from the NVM,
When it comes now to seed production or seed quality matters, we have another committee that is the seed regulation. There is in the membership, there is a representative of the Council Seed Regulation Committee.
Yes, there's a representative.
Yeah, there is a representative of the
GVRC, that is the
NGRC.
sorry, National Variety Release Committee. Maize varieties that have been, BT maize varieties that have been.
The second one is WE 3205B. 3 is WE 5206B.
So have they been released to the market?
My Lord, the 3 varieties were approved for release in the market. However, they have not been released because of orders granted by this court.
I know that is all for examination, Chief.
Yes. Yeah, quite included here. Mr. Maina.
Yes, my Lord.
Okay, it's still morning. It's already afternoon.
Good afternoon.
Yes, I will field questions just to get some clarity. Try to be brief, but I've since learned not to make promises I can't keep. I will try to be brief. The bundle is not paginated, Your Lordship, but we will try to make sure we direct you to the appropriate page as quickly as possible. So, Mr. Maina, let's look at your paragraph 9 and 10 of your affidavit. You're there, right?
Yes, sure.
So you have stated and confirmed that it is the role of the NBA to approve any activity with relation to genetically modified organisms.
Yes, my lord.
Including approving introduction into the environment of
Yes.
GMO organisms.
Yes, my lord.
So it is not the role of KEFIS to do that. That is correct.
That's correct.
Neither is it the role of the National Performance Trials Committee to do
Yes.
that.
Yes.
So that committee also does not do that.
Correct.
The National Variety Release Committee also does not do that. That's correct.
Maybe you could clarify.
Is that correct or not?
The National Variety Release Committee does not approve release of events.
Thank you. That is
Yeah.
that's a very concise answer.
The National Variety Release Committee does not approve release of events into the environment.
Good. Thank you for that clarification. So therefore, the role of KEFIS, the function that KEFIS performs, is done after the approval is granted by the NPTC.
Yes, my lord.
The role that the NPTC committee, let me call it that, and the NRVC, the National Variety Release Committee perform, are also done after the approval is granted.
Yes.
That's
Yes.
correct.
Yes, my lord.
Very well. So then, it is impossible for KEFIS, and it is impossible for the National Performance Trials Committee, and it is impossible for the National Variety Release Committee, and similarly it's impossible for you, who represents KEFIS, to authoritatively certify and confirm that indeed all the possible environmental, health and other social concerns are considered by the authority, the NBA, before issuing that approval. You cannot confirm that because you don't do that.
Yes, we cannot confirm. We don't do that.
Very well. Similarly, the KEFIS does not perform an environmental impact assessment.
Yes, my lord, it doesn't.
So KEFIS does not.
Doesn't.
That is performed by some other entity.
Correct.
KEFIS also doesn't perform the environmental social impact assessment.
Yes.
No, you do not.
We don't.
So
we don't.
You cannot authoritatively confirm that when these impact assessments are done, all the environmental, health and social concerns are addressed. You cannot.
You cannot.
Very well, thank you. Now, let's go to your paragraph 15 of your affidavit. You have, in that part, through that paragraph, annexed what you refer to as minutes of previous meetings of certain committees. I want us to go to the affidavit marked SM1, that should be referred to in paragraph 15. SM1. Yes, it's referred to in paragraph 15 of the affidavit. If your lordship has a copy, it's not paginated, so you can figure out how to direct it to it. Not fast, but since it's yours, you will know where that is. Minutes of the National Performance Trials Committee. It should be the second leaf after the end of the affidavit. So you're there, Mr.
Yes, I'm there.
Could you give the title of that meeting?
Minutes of the National Performance Trials Committee online meeting held on 2nd to 3rd June 2021. Minutes of the National Performance Trials Committee online meeting held on 2nd to 3rd June 2021. 2nd to 3rd June 2021, coordinated at KEFI's headquarters.
Very well. From that attendance, there are 15 persons. Just to clarify, we know what KEFI's is, at least but what is STAC and PBAC? That is at number 5, 6, and 12.
Oh, sorry. STAC is the Seed Trade Association of Kenya.
Sorry?
Seed Trade Association of Kenya.
That's how much?
STAC.
Number 5.
Number 5. Okay. Seed Trade Association of Kenya. And PBAC is members. They're members of the committee.
Members who are present.
Yes, members present.
Number 5 is?
Number 5 is STAC, Seed Trade Association of Kenya. And number 6 is PBAC. PBAC is Plant Breeders Association of Kenya.
And then number 11, MOLFC.
This is Ministry of Agriculture.
6 is plants.
Number 6 is Plant Breeders Association of Kenya.
Yes. The other number you asked me is?
Number 11 is Ministry of Agriculture, Livestock, Fisheries, and Cooperatives.
I should have known that. Thank you. It was right there. Thank you for that clarification. Now we can tell from the attendance who was here, now that we are clear on what those abbreviations mean. Mr. Maina, there is no representative of the Council of Governors in this attendance sheet, is there?
There is no representative because...
there's no representative?
Yes.
All right. Very well. Thank you. Okay. Just needed that clarification. Now, paragraph 19 of your affidavit, if you be kind enough to read it out, it's quite short. So.
Okay. Paragraph 19. That the third respondent, in ensuring that the right of property of other farmers is not violated, has ensured that the isolation areas set aside for the performance trials and testing are at a well-established distance that cross-pollination cannot occur.
So this is in reference to performance trials and testing for genetically modified maize?
Yes.
So you have already established these isolation centers?
Yes, yes, my lord.
So that means you already had approval from the authority to do this?
My lord, let me clarify this particular matter. Yes, there was approval from the National Biosafety Authority to use these sites.
To use these sites for the purpose of what exactly?
National performance trials for the genetically modified maize.
know when this approval was given?
Yes, that was allowed in, you're talking about 2021. Should have been 2019, 2020.
Oh, very well. And you have conducted these performance trials?
Yeah, we have conducted them already. You see, the report was already reported. The report of 2021 was reported. The varieties have been released, my lord.
When was the release done?
In 2025.
When exactly in 2025?
In January 2025.
Right. So, my last question before I leave the floor to my co-counsel. As the testing and releasing authority seats,
Yes, my lord.
do you have any regulations or procedures in place to ensure that a farmer, perhaps Willis is a farmer, unfortunately I'm not good at that, I wish I were, but assuming that Willis is a farmer and Mr. Mutari is also a farmer and the neighbors, he actually is a farmer, and Mr. Mutari is planting genetically modified variety of maize, which was released to have, tested and approved. Are there then, but Willis is not planting that variety, is let's call it indigenous. Does KEFIS have in place any regulations or any processes whatsoever to ensure that this farmer, Willis over here, knows that Mr. Mutari, his neighbor, is planting genetically modified maize? Yes or no?
My lord, when it comes to...
Do you have those procedures? Just a yes or
maybe some clarification.
We will get clarified. You first have to answer the question respectfully.
I want to understand, my lord, whether you are talking about during national performance trials testing or during commercial production.
You have done the testing.
Yes.
You have
released,
satisfied
and we have released.
and you released.
Okay, we don't have.
You don't. Very well. That is all I needed to know. Thank you very much. I'll yield to my co-counsel.
Okay.
Mr. Mwena, how are you?
Well, thank you.
I want to ask questions from your affidavit. Your testimony as captured in paragraph 4. That you apply and are guided only by the 3 acts of parliament you listed.
My lord, these are the main acts that guide our operations.
Which ones are they?
The Plant Protection Act, that is chapter 324.
What act?
The Plant Protection Act,
Plant Protection Act.
chapter 324. The Seeds and Plant Varieties Act, chapter 326. And the Kenya Plant Health Inspectorate Service Act,
The Kenya
Plant Health Inspectorate Service Act, chapter 349.
Confirmed that.
which of the first two, the Plant Protection Act and the Seeds and Plant Varieties Act, was subject of the Machakos petition.
It's the Seeds and Plant Varieties Act, my lord.
Okay.
Yes.
And you also adhere to the regulations established by this act, under this act.
Yes, my lord.
Is there any other law that you deem to be relevant for purposes of your work?
My lord, there are other laws that are relevant for our work.
Yes.
And one of them is the National Biosafety Act.
Yes.
The Pest Control Products Act, the Agriculture Act, Import and Export.
Maybe to narrow down the question.
National Biosafety Act.
Yes.
You said the pest control.
Pest Products Control
Pest Products Control Act.
Act. The Agriculture Act, Import and Export. Agriculture Import and Export Act.
To narrow the question, do you consider the Constitution an important piece of law in carrying out your work?
Yes, my Lord.
And if in carrying out your work, there is a threat to the fundamental rights and freedoms of another person, would you respect those rights of the person or you continue doing your work?
My Lord, I respect the fundamental rights of other persons.
Such that if a seed variety that you are approving is going to interfere with the rights of a third party, would you still release that seed variety into the market?
No, my Lord.
You will not. And do you recognize the rights of a farmer to plant a seed of his choice or her choice?
Yes, my Lord.
Do you recognize the duty to protect that farmer's seed sovereignty from being interfered with a third by a third party?
The question?
Do you recognize your duty to protect that farmer's seed sovereignty and to protect it against interference by a third party?
My Lord, I would be happy to restrict myself to the mandate.
So I'm asking you, you are KEFIS, you're about seed and plant health, right? So do you have a duty to protect the seeds that I have, a Kenyan has?
My Lord, I have a mandate to ensure that the seed sold to farmers meets the right quality standards.
I agree. So my question now is this. Once that seed that you've approved, do you recognize it as your duty to protect that seed which is now in the hands of the farmer? Yes or no? If you don't say you don't.
My Lord, that issue of sovereignty is beyond my area of competence.
So when KEFIS, for example, at the border, checks on what seeds, what plant varieties people are bringing, what are you trying to do when you set up at the borders and the ports?
My Lord, our role at the border points touches on matters of plant health to protect the Kenyan territory from incursion of pests and diseases through plant materials.
So who are you protecting? Is it the Kenyan farmer or is it the Kenyan soil? That's my question.
It's the Kenyan, my Lord, it's the Kenyan farmer, the Kenyan people, and the Kenyan soil, and everything Kenyan.
So we agree that you have a duty to protect the Kenyan farmer's seeds, right?
My Lord, I have a duty to protect the Kenyan farmer from incursion of pests and diseases based on the Plant Protection Act.
Yes. And if any foreign organism were to interfere with that seed, you will be the first to say no. We don't agree.
Yes, my Lord.
Let's go to paragraph 12. made reference to a committee, the Seed and Plants, the National Variety Release Committee, and
Which committee?
the National Variety Release Committee. And you indicated that a representative of the Council of Governors is a member, right?
Yes, my lord.
If you look further in your affidavit, you have indicated the concerns and consideration of the various county governments were well represented.
Yes, my lord.
Have you brought to court any memorandum or report capturing the views and representations of the various county governments on what this committee was discussing?
My lord, as I said, there is a representative of the Council of Governors in the committee. And so they are part of the business of the committee. As to how they get involved, that's a matter of the Council of Governors.
Let's just set the court. Just answer my question. You will have a chance to clarify. I will give you. I've just asked the question. Have you given the court any report, memorandum, documenting the various views, concerns of the various county governments? It's yes or no? You brought it to court.
No, my lord.
So that, having said that, if you read paragraph 12, the point where you say the concerns and consideration of the various county governments were well represented is not supported by any documentary evidence, correct?
That's
Paragraph 12 of his affidavit, where you say the concerns and consideration of the various county governments were well represented. That statement is not supported by any documentary evidence in court today, correct?
My lord, this is implying the membership, part of the decision making.
I'm asking you, this statement is not supported by any document. If there is, show me the document.
Yes, that's true.
It is not supported. And also, you have not provided a name or any identifying mark of this so-called representative from paragraph 12.
My lord,
you have not provided a name or any identifying mark of the so-called representative of the county council of governors to this committee.
in the affidavit or in the documentation? Or anywhere?
Anyway, that's all. There's no name that is provided of this person.
my lord, in the affidavit, the statement was to show that the Council of Governors is represented, because it is the Council of Governors that decide who is going to attend the committee. But the regulations are clear.
The question you are being asked.
Yes, sir. Yes, my lord.
The representative of the Council of Governors is named anywhere. Is that what you're asking?
Yes.
Yeah, my lord, it is the representative is named in the annexures.
Please show me the name.
Yes, that is a second set of minutes. After the National Performance Trials Committee, there's minutes of the National Variety Release Committee with this numbering.
Yes.
So these are members present. So there's Robert Kiteme, absent with apologies. And the member of CUG. Robert Kiteme. Yes.
What document are you referring to?
The annex, that is SM1. SM1 is a second set of, thank you.
What is SM1?
SM1 is one of the first annexure.
Is it minutes or what document?
These minutes of the National the National Variety Release Committee. Minutes of the National Variety Release Committee.
Of which date?
Held on 21st of January 2025.
And you say
1st of January
21st of January 2025.
2024.
2025. 2025. 25. 25. Penta.
confirm to the court that the person, Robert Kitema, was not present at that meeting.
Yes, yes, my lord, I confirm.
He was not present, right? Let's go to paragraph 16. You've indicated, paragraph 16, sorry, of your affidavit. Are you there?
Yes, my lord.
The third respondent is responsible for certifying GM seeds, ensuring they are true to type, genetically pure. The third respondent is responsible for certifying GM seeds, ensuring they are true to type, comma, genetically pure. I want him to read that. You've seen that?
You want to be? Yes,
No,
I've
you've
seen
seen it.
I've seen it.
Do I take it that you recognize it as your mandate to maintain gene purity in seeds?
Yes, my lord.
Gene purity.
Yes, my lord. Genetic purity.
Yes. You maintain its their duty.
Yes, my lord.
Based on the evidence that we've taken in court, and even some of the scientific reports you provided, do you agree with me that if you take a GMO maize and a non-GMO maize and plant them close together, gene purity cannot be ascertained between the two?
Plant GMO alongside non-GMO.
Yes.
The fact that they are planted side by side does not mean that any affects any other.
My question is, when you plant them side by side and taking into account the manner in which maize is pollinated, do you agree that one crop will affect the other crop?
So, to clarify, you are talking about the offspring.
No. I'm talking about maize crops. I'm a maize farmer.
If you have one maize plant here, this is GMO, this is non-GMO.
Yes.
The two cannot affect each other.
Yes, but the offspring.
They'll just grow.
The offspring.
Now, the seed that will be harvested from either
Yes.
will have a mix of the two because of cross-pollination.
So the point is, that seed will not be genetically pure.
Yes, as per the parent.
That is true, right?
That's correct.
But you have said you have a duty to ensure gene purity. So that kind of planting will affect that mandate.
Correct.
Good. Let's look at paragraph 17. Just read it loudly.
Further to the third respondent, that respondent avers that during the seed processing, seeds for genetically modified crops are well labeled as such and are traceable across all processes for purposes of ensuring safe and efficient introduction of GM seeds into the market.
Why are you concerned with labeling? What is the purpose to be achieved?
My lord, labeling is one of the most important aspects of seed quality assurance because it is an identifier. A label is an identifier, a unique identifier and contains information that can help you trace that material.
Is it your testimony that non-labeled seed varieties should not be distributed across the market?
Yes, my Lord.
It should not be distributed.
Yes, my Lord.
Back to my question earlier. If the two farmers, the one who had non-GMO maize, gets an offspring that has now been genetically impurified, and he fails to label his seeds, will he be affecting what you are saying in paragraph 17?
Please come again.
If I had given the example, my Lord, before, of where there's been a contamination between GMO and non-GMO, then now the offspring, which is now genetically not pure, if that farmer takes the seed and fails to label it, will it be acting contrary to this requirement for labeling?
My Lord, the offspring of the product in the field doesn't qualify to be seed as per our mandate. Because, my Lord, if you can allow me to explain seed production, why we are talking about genetic purity. When we are producing, seed is being produced and KEFIS does inspections. There are measures that are in place that are protected in law. For example, to ensure there is suitable isolation distance. To ensure that the seed does not get any foreign pollen.
Let us stick to my question. I told you I'm a maize farmer. We are helping the court and I'm helping myself. We've agreed that I've taken GMO maize, non-GMO maize. They planted close together. The offspring is GMO. Has been infected, right?
It has some GMO in it. Yeah.
So I decide to plant it. That offspring, I want to plant it for the next season. Is it not a seed?
No.
My question is, will that be a seed, yes or no?
My Lord, you are borrowing genetically pure from paragraph 16.
My question is, if I plant that offspring, will it qualify as a seed, yes or no? That determines if I continue with that line.
You can use it as what we call farm safe seed.
It is still a seed.
But in terms of my mandate.
No, I'm not talking about your mandate. I'm talking about me as the farmer. Is that which I have taken, that offspring, and I plant it on the ground, is it a seed, yes
You can use it as seed.
It is a seed. And that was what brings me to paragraph 17. If I fail to label, me, not you, me, I fail to label that seed as not GMO associated or infected, will I be going contrary to the requirement of labeling?
My Lord, labeling applies to certified seed.
I am asking the question, me, the farmer, not the certified. I'm asking about the farmer. If he fails to label his seed.
My Lord, as a seed quality expert, there is a way you produce seed. Already the rules or the procedure for production of seed has been breached. So I cannot ascertain that what you harvested, you can plant it because it's on your own farm and you have a right to do that as a farmer,
okay.
but I cannot ascertain as a seed expert.
I think what he's asking.
Yes, yes, my Lord.
You answered this question.
Yes.
That in your view, all varieties, all GMO varieties that are distributed must be labeled.
Correct.
So now that you say that all varieties must be labeled, now it takes you back to that particular seed which was planted next to the GMO, whose offspring now has GMO.
Has GMO.
He's asking you then, if he distributes that seed without labeling, will it be proper or is you get the question?
I get the question, my Lord, and from perception of seed quality, that seed, it's not just it has in GMO, it has many issues. Yes. In terms of quality, that quality of that seed is very poor. You cannot assure.
We are talking about the GMO traces.
Yes, what we are saying.
And that question came from your answer.
Yes.
That anyone who distributes ideally must label. It came from your response.
Yes, my lord.
Yes.
Yes, my lord. And that's what I'm trying to explain. The seed we are talking about being distributed is seed that has been produced under certain standards. The labeling only comes, maybe I should have said that, the labeling only comes when there are certain known standards that have been followed. In this case, no known standards were followed, and therefore, you can't even label because it is not clear the genetic makeup of this material. It doesn't have just GMOs, it has all other maize that is enabled.
Yes. So in other words, I will be free as the farmer to share with my neighbors this seed that is now genetically modified without labeling, correct?
Yeah, without labeling.
I'll be free to do it.
Subject to what we call intellectual property rights.
No, I'm asking you. Now me as the offspring, this was the offspring.
Yes.
I am free now. If my neighbor, my brother who is my immediate neighbor, I can give him to plant. I'm free to do it.
Yes, you can share. You can share.
And my brother can also give the church leader to plant.
Yeah, you can share.
And at that point now there is no traceability, correct?
There is no traceability. No traceability at all.
And Kenyans can now eat GMO maize even if they are aware or not, correct?
Yes, they can eat. They can eat.
Okay.
They can. Yeah.
They can eat without knowledge.
But remember.
Let's go to paragraph 19.
It's okay.
Just look at paragraph 19. Another. Paragraph 19. Can you read it?
That the third respondent, in ensuring that the right of property of other farmers is not violated, has ensured that the isolation areas set aside for the performance trials and testing are at a well-established distance that cross-pollination cannot occur.
What would be wrong with cross-pollination? Why you think it should not occur?
My lord, there is a context to this, as I mentioned in my introductory statement, that in scenarios whereby the National Biosafety Authority approves conducting of national performance trials under confinement, then it's the mandate of KEFIS to ensure that the GMO does not pollinate the farmers' fields.
So
that's why
my question is, yes, why is it important for cross-pollination not to occur? What are you protecting if there is anything?
For this case, when full environmental release has not been granted,
okay,
we are preventing escape of the DNA of the genome.
What is wrong if you allow it to escape?
It will go into the farmer's field
and
to the farmer's materials,
yes,
yet it has not been approved.
It will go to the farmer's field.
Yes,
materials,
and it will pollinate.
What is wrong with that?
Because the event has not been fully released to the environment.
So you are protecting the farmer?
Yes, we are protecting the event going out, because if NB along the way finds this material is not safe,
yes,
and already you have released the genes into the environment,
yes,
you know the implications.
Okay.
Yeah.
And those implications are irreversible.
Correct.
And you take it as your duty to protect our environment and our farmers.
Yes, subject to the National Biosafety Act.
Okay. And just in follow-up to this, how long on average does it take you as an agency to reach a conclusion that this seed is safe? How long must a seed variety be in existence for you to say, this is safe, we can release it?
My lord, we don't handle safety.
What do you handle?
Safety is handled by the National Biosafety Authority. KEFIS handles performance. As I explained, the national performance trials.
Yes.
It's about performance. We are saying this new variety is adapted to Kenyan conditions and actually performs better than what is existing in the market. So we look at the performance in terms of yield and other attributes, for example, insect resistance, drought tolerance, and so on.
Let's go to paragraph 20. confirm that it is your testimony that pollen can travel up to a distance of 300 meters.
A maximum distance.
Yes, of 300 meters.
Yes.
And that you have a duty to protect the interest of the public at large.
Yes, we have a duty to protect the interests of the public.
That is what you've said in your affidavit.
Yes.
And I want to assume that KEFIS interacts with Kenyan farmers.
Yes, yes we do, a lot.
In their reality as farmers, are they able to maintain equidistances of 300 meters between farms?
Let me explain again.
Just answer my question, then you can explain, please.
It depends.
No, I'm asking you, in your interactions, if you don't know, you say you don't know.
Some farmers can, others can't.
The reality of the most farmers in Kenya, if you do interact with them,
the reality, most of them cannot.
Most of them cannot maintain it. Let's go to the minutes. The minutes of 2nd to 3rd of June. Can you look at it?
Yes.
Look at the attendance list of those minutes. The first one, the very first one in the SN1. This committee that you are meeting with, confirm that this committee is heavy government in terms of composition, majority of the participants.
Not really.
In terms of membership, majority are from government.
Not really, because you see a lot of KEFIS there, but KEFIS is only the chair and the secretariat. So these are just, the people listed there are part of the secretariat, so they don't have a vote.
Majority of them is government, from what you've listed.
Equator number 1, 2, 3, 4, 5, 6, 7, 8. 8 of them are not government. 8 of them are not government. These are experts.
And of the experts you've listed,
yes.
Who is expert 13?
Dr. Stephen Mogo.
Do you know him?
Yes, I do.
Have you seen him in this court?
Yes, he's here.
Acting for, representing which agency when he came to court? Or if you don't know?
He's an expert witness.
An expert witness for?
Yeah. For the respondents.
So he was taking part in these proceedings?
Yes.
Which you are participating in?
Yes.
And he gave testimony on your behalf as government, right?
Yes, he did.
There's a part of your document, the unfortunate bit is that it is not terminated. It is the article. The minutes of the national, the minutes of 21st of January 2025.
Yes.
The minutes of 21st of January 2025. I want you to look at page 3. At the bottom. The one in page 3. Look at the second paragraph.
Yes.
This is your meeting. Confirm that in paragraph 2, The meeting was concerning itself with the use of pesticides in horticultural exports.
She challenged this, the paragraph that starts with she challenged. Oh,
Paragraph 2.
Up here.
Paragraph 2.
But the meeting concerned?
The meeting, the challenge was in relation to increased use of pesticides was only limited to key horticultural exports.
Yeah, these are remarks of the chair.
Yes, I'm asking. That is what she was saying is a problem.
Yes.
Use of pesticides in key horticultural exports.
Yes.
And there was no issue on maize and use of pesticides for maize, as per what the chair was saying.
My lord, I want to clarify that the chair...
No, I'm asking you the questions.
Allow me that...
Listen, Mr.
Yes.
My duty is to ask you questions. It's not your duty to clarify. Just answer my question. Okay? The chair was not talking about use of pesticides in maize, but only key horticultural crops, correct?
Yes.
Let's go to the next paragraph. The chair in that meeting noted declining government funding for the institution.
No, let me clarify.
The third paragraph.
This one?
Page 5.
This one?
Yes.
Okay.
Sorry, it's not the problem with your documents. They are not paginated, sir. Yes, paragraph 4. Sorry, page 4. Go to page 4, the last paragraph.
Okay.
Yes. Look at the challenge which is mentioned in the second sentence of the bottom, the last paragraph, page 4.
Yes.
Just read.
Objective materials to national performance trials and distinctness, uniformity and stability DOS testing remains a major constraint. Let me repeat. However, the high cost of subjective materials to national performance trials and distinctness, uniformity and stability testing remains a major constraint.
So this meeting did note that there's a funding constraint you're facing, correct?
Yes, my lord.
Go to page 5, the last paragraph.
That's the joint meeting.
You can see it.
The one titled joint meeting, eh?
Yes.
Joint meeting of...
Just read the last sentence to accelerate.
To accelerate progress, it was agreed that KEFIS and the Sea Trade Association of Kenya would jointly take the lead in identifying and engaging suitable funding partners, including both public and private sector actors with an interest in advancing seed system development.
So this meeting that is being held by a government agency has recognized that we don't have money, and now we are going to look for private players to partner with, correct?
Private and public.
I'm asking, you're going to do all public, but now you're going to look for private to help you do this thing.
Yes.
Would you know what would be the interest of the private sector if it is driving such a process?
I said, number one, we are talking about public and private
You are
sources.
public.
Yes,
so now you are paying in private sector. Would you know that the interest of the private sector, because we are looking for money,
yes,
are you aware they will also have interests, this private sector?
Correct.
And that interest will be profit. Correct?
That's true.
But I want to also reaffirm, confirm it to me, That as KEFIS, your interest is not profit.
That's correct.
It is public safety.
But we are part of the government.
I'm asking you, your interest is not profit.
Yes.
As a government entity.
We are interested in food security. We are interested in wealth creation.
Are you interested in profit for yourselves?
Not for ourselves, but for the people of Kenya. We are interested in profit for the people of Kenya.
What is your overriding interest when you do your mandate? Is it profit or public safety? That's my question.
Our overriding mandate,
yes,
is increased and sustainable productivity for our farming communities, whereby they farm and get profit.
So my question is, if you don't believe in that also, you can tell me and take it. You have a global objective to achieve public safety in what you are doing.
And that is correct.
Okay.
And public and food security.
Go to page 8. Look at the second paragraph, the second line of the second paragraph. The clarification, just read it.
It was clarified that the varieties were developed through a public-private partnership under the Taylor project, coordinated by the African Agricultural Technology Foundation, AATF, with active participation from all stakeholders, including CAURO.
Again, what you are discussing has been done through a PPP, correct?
Yes, from this statement.
And each side of the PPP has an interest to advance, correct?
Correct.
One side may be public profit, some may be private profit, correct?
Yes.
Public safety.
Correct.
Including private profits, correct?
Yes, that's correct.
Okay. Let's go to the fifth paragraph of the same page. In this meeting that you are holding, the first line, just read the first line of the fifth paragraph.
Finally, it was acknowledged that discussions surrounding genetically modified, that is GM crops, often generate heightened public interest, particularly concerning safety.
So, at your meeting as experts, you confirm that you are aware that there is public interest and concern about safety?
Yes, my lord.
When you stand in court today, can you look Kenyans in their eyes and tell them that I have fully addressed their safety concerns on GMO maize?
My lord, the mandate on safety is not for my office.
I'm asking you, this is your meeting where safety is being discussed. This was your meeting. You brought the minutes. Can you look them in the eye and tell them, I am 100% sure this is safe?
My lord, I operate under a regime, under competence. Food safety is not my, safety of GMOs is not my area of competence. So I will not talk about it.
No. I'm sorry, but I will not move on. You brought these minutes. This was your meeting?
Yes.
Right? And this your meeting brought several players?
Yes.
Correct?
Yes.
And you want the court to accept these minutes?
Yes.
Or do we disregard them?
My lord?
No. Just follow the thread. Do you want the court to look at these minutes?
Yes.
And in this meeting, you and your people are concerned about public safety.
Yes, because if you look at the constitution.
We're going slowly. You are concerned about public safety.
Yes, the committee is concerned about public safety.
Would you look Kenyans in the eye after the committee has shown this concern that your seeds, let's start with that one, are safe if we introduce GMO?
My lord, I can look them in the face and tell them the seed is of the right quality. because we have inspected, seed that we have inspected and certified is of the right quality. I have said that because that's my area of competence.
Would you tell them in the eye that this GMO seed can contaminate your non-GMO seed? Can you also tell them comfortably?
I would not.
You tell them that it cannot?
I will not.
That it cannot contaminate?
Yes.
So you are the new scientist in town who says GMO seeds cannot contaminate?
My Lord, we have more than 400 varieties of maize that have been released in Kenya. And we don't talk about contamination when the materials go to the farmers' fields. So long as the materials have already been declared safe by the competent institution. So when materials are being grown in the farmer, by the farmer, we have at the production so many varieties. And they keep cross-pollinating. And farmers harvest and eat. And there has not been an issue.
So you can tell them that there will be contamination of your seeds when this is released.
I don't want to use the word contamination because when I am involved in seed production,
which one would you use?
It's cross-pollination.
So you can tell them that your seed will have a new gene once introduced in the market, correct?
I want to take you back to my mandate, seed production. I will inspect seed in a farm in Kitale and ensure there is no external pollen that is coming to that seed. So when I give a label, I'm saying this seed is hybrid 614 and it is genetically pure. That's my mandate.
Yes.
But in terms of what is growing in farmers' field without isolation distances, without checking whether there are pests and diseases, I can't talk about that.
Good.
Because it doesn't have the quality.
In other words, there are high risks that you cannot give guarantees to.
I don't consider them, my Lord, I don't consider them risks.
No, because you say it, you can't do it. So I'm asking you, there are certain processes that will be beyond your control.
Correct.
You will be beyond your control.
Correct.
So whatever happens, happens. I was actually summarizing my note. Less than 5 minutes. And you did also bring what you deem to be an expert report here. If you can look at page 60. Page 60, the document which you annexed. This is the last part of this bundle. It was open native, but the typed. In fact, yes.
5.3.
It was open native, but it's an article.
I would ask that you file another copy.
Yeah, my Lord, yes. I have been quietly trying here. I've managed to paginate through sets here. If I can have the court one, I can also do it in the next 3 minutes. Yes, so that the court and my colleagues
we are able to follow. But I will, so since I'm concluding, my Lord, you don't have to adjourn for that purpose. Yeah. Have you seen that paragraph?
Which paragraph is that?
Paragraph 2.
Besides. Okay.
I want you to read from the pattern the removal of the first few rows.
In general, that is the beginning. First paragraph 1. The removal of this one.
Just read it.
Okay. Okay, my Lord. The removal of the first few rows of a field facing a GM crop prior to harvest might be worthwhile to reduce the total level of cross-fertilization in the recipient field.
Read that again, louder, please.
The removal of the first few rows of a field facing a GM crop prior to harvest might be worthwhile to reduce the total level of cross-fertilization in the recipient field.
What is your understanding of what your expert is saying?
Basically, what they are saying here is about these are what you call these are materials that are next to the GM crop.
Yes.
So their removal, yes, their removal from the rest of the crop will reduce the amount of material that contains the GM by the obvious fact of that contains GM. because the closer, the ones next to the crop are the ones that receive most of the pollen.
And you're aware that testimony has been given here that there is a recommended equidistance, right? Are you aware of the recommended equidistance for isolation?
For seed production, we do have that.
What's the distance?
We apply for maize, we apply 200 meters and 400 meters depending on the class of seed.
I am the quintessential
in seed production.
I am the quintessential 50 by 100 maize farmer. My neighbor is a 50 by 100 maize farmer.
Yes.
Based on what your expert is saying, if my neighbor plants GMO maize on his farm, to maintain purity, your expert recommends I remove the first row, right?
Yes.
I remove the first row. And I lose my maize, right? That was on the first row.
That is in maize production. I talked about isolated distance in seed production.
Your expert is saying, to maintain purity, I remove my first row.
Yes.
And I lose it. The GMO farmer maintains his rows and he harvests. That will be all my logic.
Yes, Mr. Maina, I need you to clarify to the court on some of the questions that have been asked. And we start with the National Performance Trial Committee. What is the composition of
My Lord, the main composition of the National Performance Trials Committee are 6 crop experts who are breeders, who are well versed with the Seed Trade Association of Kenya and the Plant Breeders Association of Kenya.
What would you classify as the work of this committee? And just in simple terms, also clarify on the National Variety Release Committee, what is the work of that committee?
It considers the report that is provided, but not just the technical elements, but also the socio-economic factors that affect that variety.
Would you kindly clarify
about a representative of the Council of Governors?
And in that, in what annexure have you provided minutes?
Annexure SM1, the second set of documents.
And what are the remarks in regard to the representative?
In this particular meeting, the representative was absent with apologies.
Was?
Absent with apologies.
So they knew there was a meeting?
Yes, my lord.
And they sent apologies?
Yes, my lord.
And ordinarily, do they?
Yes, they do.
And suppose they have any reservations as to a variety you're going to release, do they communicate?
My lord, during the meeting...
Yes, yes, my lord. Okay.
Yes, my lord, the decisions of the National Variety Release Committee is based on consensus. So if they have any problem, they'll raise it. Until all members are in consensus.
You've been asked about the roles of NBA and KEFIS do they look at the same aspects during this whole process of approving GM varieties?
Okay. We will consider matters of biosafety, has to do with the safety as food and the environment and all that. But KEFIS looks at performance. KEFIS looks at the performance in terms of yield and other attributes. And later on, once the varieties are commercialized, we look at the quality of the seed.
What is the difference between what you refer to as your mandate in terms of release and commercialization of seed? What would be the difference between the release aspect and the commercialization?
My Lord, when it comes to release, as I said, a variety is tested for its performance. Performance in terms of looking at yield, how many bags of maize is it producing and all that. Now, once that testing is done, then it has met all the requirements, it is released. When a variety is released, now the breeder has been allowed to go and commercialize the varieties. So they will now start the process of seed production. And that process of seed production is supervised by KEFIS to ensure that at the end of the day, it's a long process, but at the end of the day, the product that comes out is of the right quality to be sold to the farmers.
You were asked whether KEFIS protects seeds, and which type of seeds are you referring to? Is it registered seed for commercialization or the seed that farmers exchange among themselves?
My Lord, our mandate on seed quality is taken from the KEFIS Act and the Seeds and Plant Varieties Act. And basically here we are talking about formal seeds or commercial seed. These are seeds that you go and buy in an agrovet. We do not have a mandate as far as what farmers are exchanging is concerned.
You are given a scenario where one maize plant is GM that is planted alongside one that is conventional. Would you please expound on that, on whether they affect each other, and whether also maybe clarify whether varieties would cross-pollinate just between GM seeds or all varieties tend to cross-pollinate against each other?
My Lord, all varieties of maize cross-pollinate if they are planted one next to the other. And that has been happening from time immemorial. So I would expect the GMs also to cross-pollinate with either other maize variety.
Would different varieties, let's say hybrid or any variety that a farmer chooses to plant, would the gene purity of the neighboring farms be affected by a variety that is non-GM that is planted by the next farmer?
Yes. Whenever there is cross-pollination, the genetics of the material it collects, a maize plant will collect genes from all over based on cross-pollination. So that is affected with the produce. And that is why in Kenya, in the wisdom of Parliament, set up an act of Parliament to guide the process of seed production so that it is ensured that the seed maintains genetic purity. Otherwise, what farmers are growing out there for food, they have all manner of cross-pollination. But the idea, remember, that is being produced for food, and cross-pollination will not have any negative impact on the food that is going to be eaten, on the unga once it is made.
So it's not a phenomenon that would be only for GM maize?
No, it has been happening all the years. As I said, we have registered more than 400 varieties of maize. Farmers are growing those varieties left, right, and center. They are crossing each other, and they're harvesting maize and milling into ugali, milling into flour and making ugali.
On seed production, who normally does seed production, and what is the size of the chunk of land that they will use to produce seed?
My lord, seed production is done by growers who are registered by KEFIS, and the size of land is not restricted. It's only that there are standards that have to be met in seed production. And as I said, for what we call the high status seed, we enforce an estimated distance of 400 meters, and for the low, what we call the certified seed, isolation distance of 200 meters.
So when it comes to distribution of seeds, a person who commercializes seed, does he have to be registered with your? That is all for me.
Mr. Maize,
Yes.
my name is Bada. For the rest of Mr. Maize, I will ask you a few questions on the issue of purity, as you have been referred to in the. And I want to clarify to the court. What are the main acts of parliament which give KEFIS mandate over seed?
My lord, we have the Kenya Plant Health Inspectorate Service Act, that is CAP 349, and the Seeds and Plant Varieties Act, CAP 326.
Give me the statutes again.
That is the Kenya KEFIS Act, the KEFIS Act,
Yes.
and the Seeds and Plant Varieties Act.
Are you aware of an act of parliament which regulates crops as opposed to seeds?
Yes, my lord. We have the Crops Act.
So there are different legal regimes which regulate seeds and crops, correct?
Yes, my lord.
Please distinguish seed and crop.
Yes, my lord, when you're talking about seed, as per the Seeds and Plant Varieties Act, this is seed that has been produced through a clearly defined scheme with standards, whereby the players are vetted and the sources of the seed are known, and there are measures that are taken to ensure the final product is free of pests and diseases, important pests and diseases. Yeah, yes, my lord. I said seed as provided in the Seeds and Plant Varieties Act is produced under a scheme that is very clear in terms of the producers and also the way it is produced, the facilities under which it is handled, because ultimately it's a seed that is required to be, number one, genetically pure, a representation of the seed that is labeled, free of pests and diseases, and also it's able to meet what we call minimum germination to ensure that that seed gives the farmer maximum production. That is seed. Now, when we come to the crops, is where we have now farmers, once they buy seed, wherever they get their seed, they produce out there in the field. Now those are the crops, and that's why now there's another mandate that checks on crop production, maize production, beans production, wheat production. out there in the field. After now, it has gone through the seed process.
So clearly, KEFIS does not regulate crops.
No, we don't regulate crops. But in terms of, let me talk about the only place where we come in if there are issues of plant health. We come in when there are issues of plant health.
Plant health.
Yeah, out in the farmer's field. There are issues of plant health, then we come in. Based on now CAP 324. Yes.
So, is it a testimony, based on the affidavit, that when a farmer buys seed, approved seed from agrovet, from an agrovet, that seed is pure, having undergone the test of KEFIS?
Yes.
After the farmer has bought this seed, is it for planting or for consumption?
My lord, it's for planting.
You have told the court that there are over 400 varieties of maize in Kenya currently.
Yes, my lord.
Are those varieties that have been approved by KEFIS?
Yes, my lord.
Would you confirm, because at the moment you say there are no GM maize in Kenya, it would mean that the remaining varieties are either indigenous, conventional, hybrid, and what type of varieties have you approved as KEFIS?
My lord, for once.
Again, this is the Organization Council.
My lord,
The question again.
Please clarify the myriad of varieties that KEFIS has approved in Kenya currently.
My lord, first to clarify, number one, we don't have indigenous maize varieties in Kenya because all the maize that is grown in Kenya was imported from other countries, especially the Americas. But it's a whole variety. We have hybrids, we have open pollinated varieties. But what is approved by KEFIS, this is what KEFIS has already tested and established performance, and it's been released by the National Variety Release Committee, consisting of hybrids and open pollinated varieties.
When a farmer plants a hybrid maize,
Are you able to conclude in 4 minutes?
yes, yes. When a farmer plants hybrid maize and another farmer plants open pollinated maize, is there cross pollination between those two types of maize?
Yes, my lord.
The produce from the two sets of maize, is it pure?
No, my lord.
Similarly, is the produce between GM maize, open pollinated maize, and hybrid maize pure?
No, my lord.
As a result of this cross-pollination, does the crops which come as an output risk any harm to humans, animals, or environment?
Not to my knowledge.
That's the end of my explanation.
On behalf of the respondents, that is the close of the respondents.
The registered
also, I believe, if it's okay with the respondents that committed to supply us with the quality verified, 3 days or so, 3 or 7 days. Okay. If you have Mr. Mutari can confirm that conversation, yes, be sure.
I will request that the parties provide report with soft copies if you want of those submissions. We will appreciate. And because of the bulky nature of the documents here, and again, I don't know whether you require more time. I will again request that any particular paragraph or contents of any document, please just cite in verbatim in the submission. So it takes a shorter time than rather than for me to start going rummaging through the documents again. Yeah, I think that will assist the court and I will appreciate.
Yes, Your Lordship, that we'll try to follow up with the court assistant whether they can also have the time proceedings.
In fact, that's what I was just about to read next, that the proceedings will be typed and parties.
It's what they help us have a sitting next time. You know, to just something additional. We request the indulgence to give us 14 days after they file the resolutions, so that we do any supplementary if need.
I see. That will be another.
And then, my Lord, I don't know how long it will take for the proceedings to be ready.
We will.
The only danger, but I know the mischief I was trying to cure, since we've given us 14 days, because they may get them after we 5 hours. I meant like
any matters arising.
Any matter that's arising, supplemental submissions.
And let's do this. Let's just limit it to 30 days per year.
Because if the proceedings, for example, took 20 days to get, I don't want to lose the 30 days of doing my submissions. I still have them ready, but just in case.
That's what I'm saying. What I'm saying that the proceeding banner. That's what I'm saying that we will follow up on the issue of typing, and the parties will be notified immediately through email. Immediately they are ready.
That is 24th of September. Yes.